Many recent headlines suggested the $100,000 H-1B fee was officially dead, struck down by a federal court in a ruling that seemed to end the policy. But that relief lasted only a few days. A federal judge issued a temporary administrative stay almost immediately after the initial ruling, which brought the fee back into effect. This legal chain reaction began with the Presidential Proclamation signed in September 2025. That document established the fee as part of a broader effort to restrict the entry of certain non-immigrant workers. The government classifies this $100,000 as a payment to remove a restriction on entry. By using this specific legal definition, the administration separates the surcharge from the standard H-1B filing fees that are regulated by Congress. While the courts continue to argue over that definition, employers must deal with the current reality. Today, any strategy for hiring international talent must account for this active six-figure cost. The fee does not hit every H-1B petition. Instead, it is precisely calibrated to actively target new talent being brought into the United States from overseas. The primary trigger for the fee is a pathway known as consular processing. If a worker is outside the U.S. without a valid H-1B visa, or if an employer selects consular notification on the filing form, the $100,000 payment becomes mandatory. There are no discounts based on who is doing the hiring. From large corporations to small startups, nonprofit research labs, and even universities, all face the exact same cost if the petition involves entry from abroad. For most organizations, adding $100,000 to the cost of a single hire changes the math on international recruitment, forcing a strategic shift toward talent that is already available within the country. There is a significant way to avoid this cost: the change of status and extension exemptions. The fundamental rule is based on where the worker is standing. If the employee is already physically present in the United States in a valid legal status, the fee is generally not required. This exemption covers F1 students transitioning to a work visa and current H-1B holders renewing their stay. But this only holds if USCIS approves the change of status. If denied, the case reverts to consular processing, triggering the fee. This means the most predictable and affordable hiring strategy right now relies on identifying and retaining talent that is already residing inside U.S. borders. Even an exempt in-country petition can turn into a $100,000 penalty if there is a break in the worker's legal status or an administrative error. A major trap is the 60-day unemployment grace period. Exceeding this window forces the worker to obtain a visa abroad, activating the fee. Beware the travel trap too. Departing the U.S. while a petition is pending abandons the request, triggering the full surcharge. In this environment, a minor oversight in HR or a poorly timed trip abroad now carries a six-figure price tag, making flawless compliance more important than ever. Right now, the legal landscape is shifting rapidly. On June 8, 2026, a federal judge in Massachusetts ruled the fee was an unauthorized tax and ordered it vacated nationwide. But on June 12th, the same court issued a stay on its own order. This paused the ruling to allow for an appeal, which effectively put the $100,000 fee back into force. Adding to the confusion, a different federal court in Washington, D.C. previously upheld the fee in a separate lawsuit, creating a direct conflict between different parts of the judiciary. With the First Circuit in Boston now weighing the appeal against the D.C. Circuit's earlier decision, we are seeing a significant split in how federal courts interpret the president's authority over these fees. Because of this circuit split, legal experts expect the Supreme Court will eventually have to intervene to decide the fate of the surcharge. For now, employers should audit their H-1B pipelines and ensure they have budgeted for the fee on all consular cases. Do not make any long-term hiring decisions based on the dangerous assumption that this massive fee will simply disappear. This legal battle is far from over, and the rules could change again without warning. To stay updated on the latest court rulings and how they affect your workforce, subscribe to the HSEstudy channel.